Cosgrove finally responded to Mark Bettero's mega motion that he filed on behalf of Turtleboy. Now, this was the motion to dismiss as well as to disqualify Mello. Now, there was an additional motion that was filed at a later point, which was the motion to disqualify Cosgrove. That was not responded to quite yet. So this is just the response to the motion to dismiss as well as to disqualify Mello. Okay, so we are going to be getting into it. It's actually very entertaining, which is why we're going to take some time breaking it down and reading much more than we normally do, just because it's so entertaining to go through. But before we do, a few quick announcements. Number one, tomorrow on Thanksgiving, we are going to be having a very special, unique stream. I'm going to be joined by my brother Counsel, Solomon Radner. I'm going to be joined by Mother Counsel, who is making her second appearance on Brother Counsel's channel. And we are also going to be joined for the very first time by Sister Counsel. Now, she's not really an attorney, but she's my sister, so what else should I call her besides Sister Counsel? So we're going to be having a little bit of a family get-together tomorrow on the stream. Bring your questions, ask whatever you want. We'll see what we can address, and then maybe we'll have some other things also to talk about, maybe in terms of Brother Counsel and some other cases. We'll see. We're going to take it as it goes. But join us tomorrow. It's going to be starting at 11 a.m. Eastern, and this is tomorrow, Thursday, on Thanksgiving. Number two, there is a very special organization that I am raising money as a charity. I play once a year in a hockey tournament, an ice hockey tournament. A lot of you are already very generous to donate to the cause. It's a very, very special charity. It's called RCCS. They take care of families that are stricken with cancer, and they really help them out and provide the support and guidance that they need. So the link is in the description. Any amount that you're able to donate is very much appreciated. And also, I have to reach a certain goal in order to play in the ice hockey tournament, which is scheduled in a couple months. So help a brother out and hit that link and donate whatever you can. Okay, now let's get into the response. Now, before we get to the response, we have to remember what the motion was about, because it's been a long time. In fact, they filed this motion, I don't know, so maybe sometime, was it October, September sometime? The response, I think, officially was due in October, like 24th or 27th, something like that. And, of course, they needed an extension. They were given an extension, and then they even blew the extension. So they needed more time. So there was a motion, actually, that was filed with this filing. Okay, so this was not like if you need extra time and you see that you're not going to hit the deadline, you may go ahead and file that motion before the deadline. Say, hey, Your Honor, we need some more time. Allow us to respond to this in a late filing, and even though it's untimely. Now, that's not what happened in this case. What happened in this case is that Cosgrove filed the motion for leave to file a late response with the response that he filed late. That's not the way it's usually done, but that's what he did. And for all the people asking, most likely nothing is going to happen. Okay, it's going to be accepted, and they're just going to accept the late filing. That's most likely what's going to happen. So we got to get into the merits of what happened. So before we actually pull up the response, we have to remember what the motion was about. So we're not going to read all 88 pages to you. We're not going to do that. But just very briefly, to summarize some of the main points of the arguments that Bettero made in this mega motion. So just very briefly, let's just pull up his motion, and this is some of the highlights. Okay, so we're going to get through this very quickly, and then we'll move on to the response. During the 2 months prior to the grand jury proceeding, Tully and Mr. Mello welcomed unvetted evidence, in quotation marks, and guidance from Catherine Peter, a private citizen who they knew harbored an unhealthy obsession and hatred for Mr. Carney, which he does very effectively, masterfully, actually. What Mark Bettero does is show the relationship between Catherine Peter and Turtleboy, and then showing why in the world would an objective police officer just trust this person and just take whatever evidence they give him, right? If you know that this person harbors ill will and hatred towards your target, you got to be very careful if you want to be an objective police officer, right? So he showed that, and then still they're working together with Catherine Peter to get evidence. Now, see, he lays it all out in this motion. And then let's move on to this. Mr. Mello littered the grand jury proceeding with his improper comments, his unsworn opinions of the evidence, and Mr. Carney's intent, and by twice eliciting Tully's opinion that Mr. Carney intended to intimidate witnesses. Okay, this is the first major problem with the grand jury proceeding, and that is that there were opinions that were given. You're not allowed to elicit an opinion from anybody As a prosecutor, you're not supposed to give an opinion. This is not like a closing argument. That's not what happens in grand jury proceedings. And you're not allowed to ask Tully what his opinion is, whether Turtleboy was trying to intimidate witnesses. You're not allowed to do that. Okay, so let's keep in mind what the arguments are while we are going to read the response and see if they actually respond to some of these arguments. Because I'm going to suggest to you that if you really focus on what the arguments were, and then there's a nice 26-page response, and there's a lot said, a lot of stuff thrown at the wall, let's refocus and look at it and say, okay, did this address the arguments that Betterow made? And if it didn't, and you are Mark Betterow, which most likely we're going to see his reply, we're going to see probably he's going to highlight some of the arguments which Cosgrove chose to ignore purposely, probably for good reason, because he probably may not have such a great argument about it. So this is the first one of the first big no-nos about offering opinions. Okay. Number 2. Mr. Mello provided the grand jury with improper legal instructions and failed to give appropriate limiting instructions. He improperly alerted the grand jury about the possible sentences associated with the crimes for which he sought indictments, and even a charge for which he did not seek an indictment. So remember, this is again in the motion to dismiss. Betterow highlighted the fact that they talked about what the possible punishment would be, what the sentence would be. That's also a big no-no in grand jury proceedings. You're not allowed to tell the grand jury what the possible punishment or sentence is. And that was done in the grand jury proceedings. So, okay, keep these things in mind. These are the highlights of the arguments, and we'll see whether these are addressed in the response. Okay. Mr. Mello dedicated the first day of the grand jury proceeding to dirtying up Mr. Carney through his introduction of irrelevant and prejudicial evidence related to an uncharged allegation of Mr. Carney wiretapping Stephen Scanlon, a topic entirely unrelated to the witness intimidation allegations before the grand jury. So let's remember what happened here is at the first day of the grand jury proceedings, they spent the entire day on evidence of Turtleboy illegally wiretapping Scanlon. And what do you know? After that entire first day, they never even brought charges for wiretapping. They just completely dropped it. And aside from just tainting the grand jury in that way, and this is just a way to attack his character, Mello did not give a limiting instruction or a curative instruction to the grand jury saying, hey, we know that we spent an entire day on this wiretapping stuff, and we even read to you the sentence associated with it the first day, but you should all know that that's completely irrelevant, and you shouldn't even have it in your mind at all for consideration. Wipe it clean from your mind. That instruction was not given. Okay, so that's another problem that he has. We're going to see, did they address this in the response? Let's move on. Mr. Mello forwarded many of the communications relevant to the instant motion to dismiss the indictment to co-counsel Robert Cosgrove on December 16, 2024. But Mr. Cosgrove didn't provide them to the defense until July 7th, 2025. Notwithstanding specific defense demands for that exact evidence addressed to both months before the defense filed the first motion to dismiss the indictment. Okay, so Cosgrove has these emails. He has them December 16, 2024. He did not forward them to the defense until July 7th, 2025. Let's see if this is responded to in their motion. Let's continue. On September 4th, 2025, the defense learned for the first time that Tully apparently edited and renamed Mr. Carney's content, and that this altered evidence later became the exhibits used by Mr. Mello and Tully to mislead the grand jury about Mr. Carney's alleged intent. So this was, again, where Tully renamed his episodes to make them look a lot worse. And that's what they showed. They had a whole chart of like 27 times when they renamed the episodes, Turtleboy's episodes, to make them look a lot worse. Right? So that was another problem, another tainting of the grand jury proceedings. The DA now claims that numerous private links containing discoverable information about Mr. Carney that Ms. Peter provided to Mr. Mello and Tully has since been deleted by a private party. So you remember that there were certain links that Kate Peter sent to Mello or Tully, and then those links are no longer active. They cannot even get whatever was in that link. So that's potentially definitely exculpatory information, and they're not able to access that anymore. So not even able to turn it over. The Commonwealth has represented that Tully has never opened any unsolicited links emailed to him by Ms. Peter. Notably, they have not and cannot say the same about Mr. Mello, who not only opened private links sent to him by Ms. Peter, but sent them to Tully for him to review. So even if you're going to say, well, we never opened the link, so we don't even know what's in it. Well, Mello did open the links. So Mello does know what's in it, and we weren't provided that information, right? So that is another argument that they make. Okay, so that I think really sums up succinctly what Betterow was arguing in the motion to dismiss. And now we can have a better idea of what the allegations are. And now let's see what the response is. Now, there is a lot of rambling in this response. Okay, this is, now I got to say, I have to say it, that I enjoyed reading this. It was very entertaining for me. Okay, because you guys know how much I like snark and sarcasm, and I love that stuff. And this response is littered with it. Now, some may argue that, it's more effective if you're able to, throw in some snark at a well-placed, area in the brief. And if the entire brief is snark, then it's just a comedy skit. So I enjoy it. It's an entertainment, but it may not be the most effective way to use snark. So I will say that it could be that there is a certain line, which, okay, it's getting too snarky at this point, like too much snark. And I enjoy every line of it. So if you want to entertain me, definitely put it in every single line of the brief and I'll enjoy it. I'll be laughing. But, you are in court and maybe you shouldn't turn this into an entire comedy skit. But that's what happened in this motion, which is why in this response, which is why I'm going to be reading a lot of this response, because it's just very entertaining. And I actually hope that I get all the words, I pronunciate the words correctly, because some of these words are also not the more commonly used words, but we'll do our best. So let's see what the response here is to the motion. The defendant has filed a group of documents supporting an unfiltered motion or motions. Most notably, what is effectively a motion for reconsideration of the denial, in large part of the defendant's previously filed and decided McCarthy-Odell motion to dismiss. So something you have to understand is that what happened here was there was an initial motion to dismiss that was filed. Okay, you have to remember that this Betterow motion to dismiss is the second motion to dismiss. There was a motion to dismiss that's already filed, and that is where the judge ruled, I think it was Doolin, ruled that Proctor's witness intimidation claims are thrown out and Buchanan's are thrown out and maybe some other ones. So there was a motion to dismiss, there was a hearing on it, and there was an order. Now, so this is another motion to dismiss. Now, a lot of the reason for this new motion to dismiss is because, number one, they didn't have all the information that they now discovered. So now you are able to renew a motion to dismiss if there's newly discovered information, newly discovered evidence, right? We didn't know that you were hiding and sitting on all this information. So therefore, we could file this motion to dismiss now, right? Also, that there's another component here, another part of this, another factor is that if you're also arguing for egregious prosecutorial misconduct, then you can also bring up the fact that everything that happened in the grand jury adds to that claim. Okay, so even if, let's just make this clear, even if at the point when you filed this motion to dismiss, let's say 8 months ago, the judge felt that the grand jury proceedings, okay, maybe there's some problems, but not enough to dismiss the case. Well, now compound everything that happened then with what we're now discovering today, or as the month leading up to this motion, and now you compound it all together, the totality of everything going on, that does equal egregious prosecutorial misconduct. Okay, so it's not just like, okay, the judge made a motion on, the judge made a ruling about this earlier, and therefore we're not going to reopen that whole hearing. Yeah, well, you could look at that if the basis for your motion to dismiss now is egregious prosecutorial misconduct, and then you have to look at everything that happened on the case. Okay, but the first part where they're going to be arguing here is that, well, you have to remember that this was a motion to dismiss that was already filed, and there was already a ruling about this. You can't just refile everything that you don't like the ruling about. Right? We spoke about this on our channel a bunch of times. When you even want to file a motion for reconsideration, which is what they're going to try to claim that this really is, it's dressed up as a new motion to dismiss, but really it's a motion for reconsideration, then there has to be new facts that you discover or a new law. You can't just refile the same motion, say, we don't like the outcome, so let's refile it again and relitigate the same issue, right? That everybody kind of understands. But if it's not the same basis that you're looking for, or if there's newly discovered information, then you could. And as Betterow lays out in the motion to dismiss, there's a lot of new information here. Okay, but they're going to kind of cherry pick and say, well, some of this you knew before and you didn't bring it up, so therefore it's waived. That's kind of what the first argument is going to look like. All right. Now, the first thing that they attack here, which I quite frankly thought that they might do, they might be petty enough to do, is that Betterow called it like an affidavit in support of this motion to dismiss, but he never actually called the thing a motion to dismiss. So they're going to say, well, we don't even know it's an unfiled motion. This is really an unfiled motion because this is just an affidavit. And even though it lays out all of the facts of the motion and it's accompanied by a memorandum of law, but you just didn't label it properly. And let me tell you something. If you're Cosgrove, you don't want to get into the technicalities here about what, if you're crossing your T's and dotting your I's, because when you file something a month late, you may not want to be the one that's going to be dying on that hill, right? Because you will die on that hill. All right. Well, anyway, fine. So first they attack that by this unfiled motion it's supporting. Okay. All right. Yada, yada, yada. After setting forth these aims, and by the way, initially I started highlighting everything that I'm going to talk about, but then I started realizing I'm going to read a lot of this because it's very entertaining, and there's a lot to talk about. So you'll see that I first started highlighting it, and then I stopped because I'm just going to highlight the whole thing almost. And you know that I don't like to do that on this channel. I don't like to read the entire response or brief, but it's very entertaining. It just happens to be, I found it that way. So we got to get through a lot of this. All right, let's get going. After setting forth these aims, right, and this was the different reasons why he was moving to dismiss the case, and also asked for an evidentiary hearing, the Beddoe affidavit first lurches into a section entitled Background, which is essentially a hagiographic portrait of the defendant as a crusading, heroic journalist, fearlessly pursuing the truth, exposing the falsehoods of the Commonwealth's witnesses in the Karen Read case, laying bare the corruption of local and state police, maybe. And then it's just hard to read here because there's a stamp from the court on it. Something about resisting the attempts of the forces of evil, also known as the Norfolk County District Attorney's Office. Now, you may think that this was all sarcastic. Some people may not be so sure. Some people are like, yeah, that's exactly what he's doing. But I think they meant it as sarcasm. As your appointed snark daddy and king of snark, I think that their intention here was to be snarky and sarcastic, although I think a lot of people would be reading this and say, yeah, that's exactly what he's doing. What's your issue? All right. Anyway, let's continue. To deter him in his courageous and never-ending battle for truth, justice, and the First Amendment. In reading Beddoe's encomiums to Saint Carney. So this is where they refer to him as Saint Carney. So now, as we know about his preferred pronoun, as we know before, is Dr. Turtleboy. And now they're canonizing him as Saint Carney. So we'll probably most likely hear on Turtleboy's next show that his new preferred pronoun is Saint Carney. Okay, so you heard it here first. That's what I think we're going to hear next from the next Turtleboy show. All right, so, and encomiums is not a word that you see every single time in a brief, but that has to do with becoming a saint, saying very positive things about a saint. Okay, anyway. So, in reading Beddoe's encomiums to Saint Carney, one is irresistibly reminded of Oscar Wilde's comment on the death of Little Nell, the virtuous child in Charles Dickens' The Old Curiosity Shop. One must have a heart of stone not to laugh. The Commonwealth has had occasion to respond to such drivel in the past, and with some reluctance, now does so again. So, they're kind of saying, we've already responded to so many of these things because this was already brought up in the first motion to dismiss. But, Beddoe trying to paint Turtleboy as this crusader for justice is what they're saying is laughable, right? Okay, that's the response anyway. Rather than reinvent the wheel, it quotes liberally from its response to the defendant's previous motion to dismiss, and this is where they lay out how terrible Carney is. Okay, he's such a bad guy. He just says things, and it's so mean. Okay, fine. So, yeah, they try to, that's showing what type of guy he is. All right, now let's move on. And that there was some connection there with the Karen Read and whatever. Okay, all the stuff that you've already heard about. Let's move on. So the first argument is essentially what we spoke about, which is that this is already litigated. This is already litigated in the first motion to dismiss. So what are we doing here again? So this is, again, however, he did not. So he's saying that even though now you're raising some new arguments in your motion to dismiss that you didn't raise before, but that's your problem. However, he did not bother to raise any argument concerning the absence of a wiretyping indictment alleging that Scanlon was a victim, and neither did he complain about the accuracy, completeness, editing, or titling of the video excerpts introduced as exhibits. So you never complained about this before. You're complaining about it now, but guess what? It's too late. You knew about this all before. You should have known about it, and that's your fault. That's on you. So you can't relitigate it now. That is their first argument here. And again, that's the thing. Now the defendant wants to do it all over again. So again, saying, well, this is really just a motion for reconsideration, and you can't just file a motion for reconsideration unless there's new evidence or new facts. Renewal, having this, quoting some law here, renewal, however, is typically appropriate where new or additional grounds are alleged, which could not reasonably have been known when the motion was originally filed. So again, the fact that you didn't make the argument initially, that's your fault, right? That's on you. If you had all of the facts and evidence before you, so the first part of this is to show anything that you could have argued before and you didn't, that is considered waived. Now, again, there's two different factors here. Is this waived for that specific issue and that specific item, and you can't bring up that item? But what about if you're arguing, again, for the egregious prosecutorial misconduct here? And now we have additional information which shows more misconduct. Then, of course, you can talk about the misconduct that happened before. That wasn't the subject of your motion. That wasn't the basis of your initial motion to dismiss. If now the basis is more about egregious prosecutorial misconduct, then of course everything that you argued before is relevant and could be argued again in the full context of everything that happened. Okay, but they're trying to separate this. They're trying to say, no, let's just look at this as a motion to dismiss by itself, and you already argued these exact issues before, or at least some of these issues. And obviously some of it was not known before, which we kind of spoke about in the going through summarizing what the arguments were, and we're going to get back to them as we go on. Motion for reconsideration shall be based on newly discovered evidence that could not be discovered through the exercise of due diligence before the original motion was filed. 2, a change of relevant law, or 3, a particular or demonstrable error in the original ruling or decision. A motion for reconsideration shall otherwise raise no new grounds for relief not raised in the original motion or opposition, and shall not reiterate previously advanced arguments, yada, yada. So this is, again, all the just arguments that you're really just dressing this up as a new motion to dismiss. This is really a motion for reconsideration. And guess what? For a motion for reconsideration, there has to be some newly discovered evidence, which a good portion of what you're arguing about, some of the edits that were done to the videos, you had all that information before when you filed that first motion to dismiss. So you can't just argue them again. In his initial motion, the defendant did not attack, as he now does, any of the video evidence offered by the Commonwealth. So too bad, you can't do that now. So as they're going, let's just go through this, and then we'll see their different attacks here. So again, in his initial motion, the defendant did not attack, as he now does, any of the video evidence offered by the Commonwealth. For his present motion for reconsideration, and again, this is them changing this motion to dismiss into a motion for reconsideration. For his present motion for reconsideration, he now claims that the prosecutor and Detective Tully deceived the grand jury by grouping videos the Commonwealth offered as evidence of intent on a folder on a thumb drive exhibit labeled as intent, right? That's what Tully did here. He had a separate folder labeled intent, and during the grand jury proceedings, he would say, okay, let me get the next video from the intent folder in front of the grand jury, and let me get another one from the intent folder, and this is another one from the intent folder where the whole charge relies on whether there's intent or not. But okay. 2, showing edited clips that allegedly deprived the grand jury of viewing Carney's actual full episodes, right? That they only showed them portions of the clips. That was another argument that Betterow made, right? That you can't just show 3.5 seconds of a 3-hour presentation and say, well, now you got all the evidence in front of you. Now you got to show the full context of what he's saying. 3, assigning titles to the edited clips that did not match the titles as Carney assigned the full episodes. Although, as the Commonwealth will shortly develop, these arguments have been entirely waived by their omission from the first motion to dismiss, it first stoops to briefly address the substance of Carney's newly raised claims concerning the videos. So, number 1, Tully never testified that Carney created the thumb drive folder labeled intent, into which Tully placed videos showing Carney's intent, and no reasonable juror would have drawn such an implausible inference. Okay, so the first argument is, well, Tully never testified that Carney created the intent folder. Now, he didn't say that I created it either, right? He didn't say, by the way, ladies and gentlemen of this grand jury, you should know that I created this folder. He didn't say that either. He just pulled it out from the intent folder. So their argument is, well, Tully never told the grand jury, or Mello didn't tell the grand jury, that this intent folder was created by Carney. Yeah, you're right. But when you're in front of the grand jury and you're the prosecutor, you have to make sure that there's no questions in the grand jury's minds about who created that folder. Right? You got to tell them Tully created the folder, or they shouldn't think about who created the folder. Maybe you can do that as a limiting curative instruction. That we see that we showed you an intent folder, but just that you should disregard the labels of the folder. At the very least, that's what you should do. That wasn't done. But the first argument, again, is that, well, Tully didn't say that Carney created the intent folder, and no reasonable juror would have drawn such an implausible inference. Now, hold on to that thought for a minute, because we're going to see later on whether that thought he's going to kind of contradict himself. But again, no reasonable juror would have drawn such an implausible inference that Carney was the one who created the intent folder. No juror would have thought that. All right? Hold on to that thought as we continue. Moreover, the jurors had available for viewing the video clips themselves and could view them and draw their own inferences as to Carney's intent. So, the next argument is, well, the jurors had available for them the viewing of the clips. So who cares what the folder is labeled as intent? They could view them and draw their own inference by just watching the videos. So they watched what he said. Who cares if they got it from a folder called intent? And the answer is everybody cares. What do you mean who cares? Because you're infecting the jury. When they see 100 times the intent, word intent, ask psychologists what that does to a person's brain. It puts the word intent in their brain, right? And then when they start watching videos, they start thinking intent and they start associating it with intent. What is the suggestion here? Oh, well, they can just ignore labels. Well, then why label it? They can just ignore any label at all and just concentrate on the video. That's not how this works. Every piece of information that you put in front of the jury could affect them, the way that they think about things, the way that they look at things. So of course it could affect the jury by you constantly pulling out these clips from the intent folder that they keep seeing the word intent and that flashing in front of their brains 100 times during that grand jury proceedings. Of course it could. Anyway, the argument here is that it didn't, or it shouldn't. Continuing. Counsel's use of the term edited to describe the clips is artful in falsely implying that the contents were somehow modified or distorted. Now, what does edited mean? When you say, and this is what their argument is, when you say that somebody edited somebody else's video, it sounds like they changed it, right? Maybe they used some AI to change something that Carney was saying. And that's what they're arguing here is the suggestion by Betterow, that Betterow kept saying it was edited. They edited the clips. Now, what he means is that they edited the entire 3-hour clip and only played for them a small portion of it. That's what he meant. But they're saying, well, edited sounds like they changed it or modified it or distorted it. Were that so, one might expect the 88-page affidavit to offer examples of the edits, but there are none. And that is because the edits consist entirely of exact clips of relevant content broadcast by Carney. The only editing is selection. The appropriate course, according to counsel, would have been to show the entire episode for each show, or by Mr. Carney's count, over 50 hours of content. So what's the only other option? This is Cosgrove's thinking, right? What's the only other option is to play the entire video. Play all 3 hours. Now, I don't think Better would have a problem if they play all 3 hours. I mean, they would see that there's just a guy who's ranting and raving, on a YouTube show. So I don't think he'd have a problem with it. But think about it yourself. Is there any other option? Either playing a 3-second clip or 50 hours? Is there any? Can you think of any other option possible? Any other alternative to not playing all 50 hours? How about playing the entire clip in context of what he was saying? How about the first 5 minutes and the last 5 minutes before he said that clip? How about that? Not all 5 hours. Just a few more minutes of context, because context is everything, right? If you take a clip of somebody saying, I punched that guy in the face, and you clip out the end of the statement, which was in self-defense, well, then, yeah, you completely changed his story. You edited his story. You changed it. You modified it. You distorted it. But I said that. The person said that. He said, I punched him in the face. Yeah, I did say that. But when you destroy the context of what I'm saying, and what I was really saying is that I punched him in the face in self-defense, you completely changed it. A half-truth is a lie. So, yeah, actually, their use of editing that you have to distort it, that was achieved in this case. That was achieved. But anyway, let's continue. Prescinding from any question as to whether subjecting the grand jury to such an extended dose of Carney video would have violated the constitutional prohibition against cruel and unusual punishment, and I like the snark, so they get an A+ in snark here, no questions asked. Whoever wrote this, I don't know if Cosgrove wrote this. I'm not sure if he has that much snark in his body or his bones, but you got to give it to them for the snark. Okay, so again, Prescinding from any question as to whether subjecting the grand jury to such an extended dose of carny video would have violated the constitutional prohibition against cruel and unusual punishment, such a course would have inserted confusing and irrelevant material, and doubtless would have generated additional defense arguments that Carney was prejudiced because the Commonwealth presented evidence of other conduct for which it did not specifically request indictments. So they're saying, well, if we would subject them to this cruel and unusual punishment of playing all of 50 hours of Carney's of Turtleboy's videos, right? Well, then they would also come back to us and argue, well, then you shouldn't have played all 50 hours because, you know, in 30 hours of them, he's just screaming and ranting and raving about something else, and that prejudiced the jury to look at him as a crazy man or something, and that's why they would indict him, right? You can hear the argument the other way also. Now, quite frankly, like I said, if they would see the entire 3-hour rant from Turtleboy and taking his turtle chats and whatever else he's doing, that they would say this guy is he's just a YouTuber. He's screaming at the screen like I'm doing right now, and they would say this isn't witness intimidation. Now, but let's just take it the other way, right? The other way is that, well, if they would have played it, so then they would have used it. They would have used the portions, all those extra clips. They would have argued that wasn't necessary and that prejudiced the jury, the grand jury, to indict him, right? They would just use both arguments. And that's possibly true, but there is an alternative here. The alternative here is to just play things in context. Don't just play a 20-second segment. You've got to play at least a couple of minutes to see what he's saying before, see what he's saying after. Okay. All right. So, and then they're going to say, okay, what about the rule of completeness here? You know, there is such an idea of a rule of completeness. So he's saying, well, it's not always the same thing when it comes to the grand jury proceedings. You don't always have to present everything, which, again, this is kind of like the argument of this is already getting into the question of the line of when you don't have to technically follow all the rules of evidence in trial, and when you're distorting the grand jury, when you're confusing them or you're prejudicing them to indict somebody. All right, so it really toes a very, very careful line there. Really pushing the line. Okay, let's move on. The grand jury hardly could have been misled by the titles Tully used to identify the excerpts he played for them, right? So now, remember, this was one of the arguments, right? So when we come back and we say, okay, what did they respond to? What did they not respond to? They definitely did respond to this. This is one of the arguments that Betterow made, and that was that Tully renamed them. He renamed the episodes from the harmless names that Turtleboy called them, and renamed them as, you know, like destroying his life, trying to destroy Colin Albert's life. So let's see what the response here is. The grand jury hardly could have been misled by the titles Tully used to identify the experts he played for them. Consider the specific examples which the defense singles out as misnamed and misleading episodes. Those titled by Tully as trying to destroy Colin Albert's life. Life as normal is over, and impromptu live, Albert should be afraid, right? So all of those were the titles, right? Those were the titles that Tully renamed on his own. He renamed them himself. These were not the titles that Turtleboy gave them. Okay, and this was part of the argument. Can't change the titles and make it look a lot worse. Here's the answer. Here's their argument. All of those titles were taken from Carney's exact words, which the grand jurors saw and heard him speak as the YouTube clips were played, and which this court had as exhibits at the defendant's previous McCarthy-Odell motion to dismiss. So this was part of the motion to dismiss, or at least they had them in the motion to dismiss earlier that was filed, right? That goes back to their first argument of waiver. But the point here is that, well, he did say these words, right? The argument here is that Turtleboy did say those words in his YouTube videos. He did say those words, and Tully just used those words to rename the titles of the video. Okay, so it's not like Tully made up how to name these videos. It's the titles. He didn't make them up. He took exact words that Turtleboy said in that YouTube presentation, and he used them as the title. So they're saying, you know, how can this be so bad? This is what Turtleboy said himself. So who cares whether Tully titled the video with those words, right? And let's see, if there's any prejudice to the defendant, Carney himself was the author of it, damned not by sinister manipulation by the Commonwealth, but out of his own mouth. Okay, so he said it anyway, so who cares if this is what Tully used to name the titles? And the answer is, of course, it makes a difference. Absolutely, it makes a difference. There's no question about it. Because the question, when it comes down to intent, if the question for the grand jury is intent, which it is, witness intimidation is all about intent. What did this person intend? You need to prove that to get witness intimidation. That's why there is an intent folder, right? So if the point is intent, then yes, how he titles his video is critical to that analysis. If he says those words in a 3-hour rant, that doesn't mean that the intention behind this video is to intimidate witnesses. But if he would have called, if Turtleboy himself would have named these titles the way that Tully named it, then it really looks that his intention is to intimidate these witnesses. Of course. What in the world are you talking about? Of course it makes a difference how you titled the episodes. It makes all the difference in the world because you've got to prove intent. How do you prove intent? By showing which actions you've done. So it's different, your actions in a 3-hour rant, than also your actions in how you titled your video. Of course it makes a difference when you're trying to prove intent. But they're trying to make the argument that it doesn't, because look, at the end of the day, during the 3-hour rant that Turtleboy was going on, he mentioned these words. Yeah, but then you got to watch the 3-hour content, or at least the minutes leading up to the minutes after that. But of course it makes a difference. Of course it makes a difference what Turtleboy himself decided to name the episode. All right. Moving on. Also, some of Tully's titles for excerpts were far more anodyne than the... You need a dictionary. You really need Buchanan's dictionary, Webster's dictionary for this also, because they decide to use these $1 million words that you never find in briefs. But that's part of the fun. Okay. Also, some of Tully's titles for excerpts were far more anodyne than the Carney titles for the full episodes from which they were taken. So here they're going to actually make the case, and this is one of the most entertaining parts of this brief. They're going to actually make the case here that Tully watered them down. He made them less offensive and less scary, less intimidating. To pose two rhetorical questions, if Tully's purpose were to use the excerpt titles to inflame the grand jury, would he really title the excerpt from episode 580, Elizabeth Proctor, Dumbest Wife Ever, Brian Albert Apposition Motion, the bland call to Elizabeth Proctor? Meaning, look, we found one or two instances where Tully changed it where it doesn't look so bad. Yeah, you're right. You found 2. What about the other 27? What about the 27, which he changed from very simple titles to things like Your Life is Over? How about that? Maybe, so was that to inflame the grand jury? Why do you do it? But they're trying to, this is again, this is not where they want to get in. This is not the type of battle that they want to get into, to show which episodes Tully changed and he made them look better or worse. They're not going to win on that battle. So should have left out that argument, but they anyway make it. Okay. So then this is where they get into, okay, but they obviously waived everything. And we just have to read some more snark here. At the time he filed that motion, he obviously had available to him the full episode names for this time around. He has lovingly memorized in a 3-page chart. He had all the relevant grand jury transcripts containing each and every word of Tully that he now calls to the court's attention, including all the titles designated, the clips played for the jury, which he previously ignored, but now excoriates. All right. So moving on. Finally, even straining charity to the point of believing Carney was oblivious to the obvious at the time he filed his McCarthy-Adele motion. Meaning, again, their first argument here is that they knew a lot of this stuff before, and they didn't bring up the arguments before, even though these may be good arguments, even though they try to excuse some of this, which didn't work at all, as we just saw. But even when they try to excuse it, but they're going to say, well, look, you could have argued this before, you didn't, so sorry, it's waived. But finally, even straining charity to the point of believing Carney was oblivious to the obvious at the time he filed this first motion to dismiss, the Commonwealth's opposition to that motion clearly should have alerted him to the issue in time to raise it at oral argument before Judge Doolin. Attorney Betterill correctly surmised that undersigned counsel had been unaware that the excerpt titles came from Tully, not Carney, relying as undersigned counsel did on the exhibits introduced before the grand jury. So now what he's saying is that, the prosecutor himself, the undersigned counsel had been unaware that the titles came from Tully, not from Carney. relying as undersigned counsel did on the exhibits introduced before the grand jury. Meaning what he's saying is that I also thought they were from Carney. I thought they were from the Turtleboy. However, for whatever reason, undersigned counsel nevertheless did notice. I did notice one retitling and scrupulously called it to the attention of the court. Now stop for a second. Hold on a minute. You're trying to say now that, first of all, I had no idea. I thought maybe Carney titled them. Didn't you just say before that the grand jury could not have made that assumption? Didn't you just say that the jurors on the grand jury before would not have assumed that Carney created the titles? And same thing for intent folder, right? Same argument should work, right? Before you said it doesn't make any sense that the jurors would think that Carney created the intent folder. But now you're saying that you thought that Carney created the titles of the episodes, right? And now you're saying that, however, for whatever reason, undersigned counsel nevertheless did notice. I noticed one thing. I did notice something, and I brought it right away. I scrupulously called it to the attention of the court. Well, hold on a second. Didn't you just say that it doesn't make a difference? Didn't you just say who cares what they call the titles? Because if he actually said these in the video, if he said these statements in the video, so who cares if they call it by that or not? The point is what he says in the video. So why were you so proud of yourself that you scrupulously called it to the attention of the court? You just said before that it makes no difference. Who cares? As long as what he said, and that's what the jurors based the decision on. And it doesn't matter what the titles are. It doesn't matter what the folder is. Okay. So, the attention of the court in discussing the video excerpt confronting Jennifer McCabe at a lacrosse game, undersigned counsel stated that apparently the title was assigned by the Commonwealth. The video comes from a Turtleboy live broadcast entitled "Asking Jennifer McCabe That Question, Does She Know the Answer?" So you see, I did what I'm supposed to do. When I did find out one mistitling, so then I brought it scrupulously. I scrupulously brought it to the attention of the court. So why was it so important for you to bring it to the attention of the court before? Was it important then and not important now? Did something change? Well, you just argued before that it's not important at all. Okay, moving on. Now I'm going to talk about Kate Peters' involvement. Carney acknowledged in passing the existence of his prior motion to dismiss, but asserts that he filed it without access to undisclosed evidence, which he claims is important. The defense designates two such pieces of evidence. First, communications between Ms. Peter, Mr. Mello, and Tully, which was critical, and if disclosed promptly, would have been included in support of the defense's first motion to dismiss, right? So this is what we have, that we didn't have. This is what Beto argued, that he did not have this piece of evidence, the communications between Catherine Peter and Mr. Mello and Tully. So, okay, now we got it, because they have to do something with this, right? They can't argue, well, you had this information before. They didn't. So there's no waiver here. There's no waiver argument here. So what are we going to do with this? And so that was the first part. Second, the previously discussed presentations at the grand jury of excerpts from Carney's broadcast that were labeled by Lieutenant Tully. So they didn't know about that either. The defense claims that it learned of this for the first time on September 4th, 2025. As fully demonstrated above, that contention is risible. Show me where else you find that word risible, which just means like laughable. All right. It is true, however, that since the previous defense motion to dismiss, the defense has acquired communications among Special Prosecutor Mello, Lieutenant Tully, and Ms. Peter, and so has new evidence. So they're saying it's true. It is true that you've got new evidence in September 4th of 2025. All of a sudden, for some reason, we were sitting on these emails, but now we forwarded it to you on September 2025. So they're acknowledging that now they have it, and it's new evidence. That being undisputed, the remaining legal question for this court is whether the significance of that evidence is such that substantial justice should dictate an undoing of Judge Doolin's previous denial of the defense motion to dismiss. It should not. So, is that enough? Is that enough to now undo Judge Doolin's previous denial of the defense motion to dismiss and now say, hey, look, there's this new evidence. We just turned it over. If we would have known about it before, we would have brought in the motion to dismiss, and now we have to reopen this whole hearing. Well, they're arguing it should not. There's a factual dispute that the court should resolve. The defendant paints Ms. Peter as a member of the prosecution team. Indeed, the dominant player to whom Special Prosecutor Mello outsourced investigative work. Well, she was the one clipping all these and showing all these clips to Tully. Per Bettero, Mello was supposedly aware that she edited Mr. Carney's content with her own editorial slant and bias and reviewed private links she sent him 2 days before the grand jury proceedings started. The implications of the latter assertions apparently is that Mello and Tully were spoon-fed maliciously edited clips by Miss Peter, which they then mindlessly regurgitated as grand jury exhibits. Lieutenant Tully's affidavit demonstrates that that is not the case. Ms. Peter was not part of the prosecution team, but a source of information among many sources. She was just a source of information. The primary source of information was the victim of Carney's broadcast, who complained about them to the Commonwealth. Although, to be sure, Peter may have, so the victims were the primary source. But Carney, Ms. Peter also did stuff, did provide some stuff. The primary source of information was the victims of Carney's broadcast, who complained about them to the Commonwealth. Although, to be sure, Peter may also have brought some of that information to Mellow's or Tully's attention. In each instance, Tully went himself to the internet, viewed the allegedly offending material, copied it if appropriate, and presenting it to the grand jury, named it in a way that accurately identified its contents, usually using Carney's own words as contained in the excerpt. So again, accurately identified its contents by changing the titles, right? That's what they're referring to here. The defendant's bald assertion that the Commonwealth employed Ms. Peter to clip, edit, and rename Mr. Carney's episodes and then conceal the actual episodes and their accurate information from the grand jury's consideration is an outrageous and irresponsible untruth. So, no, this was not done by Catherine Peter, okay? Kate Peter did not rename them, okay? Leave her alone. That was Tully. Tully renamed them, okay? So take the pressure off of Kate Peter. In but 2 instances, the Commonwealth of necessity did use the exact videos provided by Ms. Peter. Oh, so hold on a second. In but 2 instances, the Commonwealth of necessity did use the exact videos provided by Ms. Peter, because those videos were no longer up on the internet, allegedly because they had been removed. Both were wiretapping claims. So we do know that there were videos that were provided by Catherine Peter and the Commonwealth used without going to the website, because you know why? They were no longer available. So they did trust Kate Peter with these videos. And they trusted her even though she is the archenemy of Turtleboy. And they knew that. So they're actually acknowledging this. They're saying it's true. In 2 instances, they did it. Now, they're going to argue that, well, but that has nothing to do with the witness intimidation charges. Those videos had nothing to do with it. Those videos were wiretapping claims. They were the wiretapping claims which are dismissed anyway at this point, right? The Lindsay Gattani and the Scanlon. So we didn't bring the indictment against him for Scanlon, and Lindsay Gattani was dismissed. So there's nothing really to talk about. There's nothing here, because even though you're right, even though we said a million times that we didn't really just trust Kate Peter, but you're right. I guess at this point we have to acknowledge that we did trust her twice, because those videos aren't posted anymore online. So they must have trusted Kate Peter, but that had nothing to do with witness intimidation. Okay, so don't bother with that. Let's ignore that fact, and just trust us. Those are the wiretapping claims. This is why maybe you'll need an evidentiary hearing to flesh that all out. At trial, a defendant might well contest the authenticity of these recordings, but here the Commonwealth had a good faith basis for believing them to be accurate based on the statements and testimony of the involved witnesses. So you're right. We kind of trusted her, but then we also corroborated them with the other witnesses, with all the complaining witnesses, and therefore it all made sense. So therefore, we had a good faith basis of providing them, even though, again, Kate Peter is the sworn archenemy of Turtleboy, but we it corroborated with the other witnesses, so we had a good faith basis for showing them. There was no impropriety in their introduction at all. No impropriety at all. Let's just ignore this fact and let's move on. Right? That's essentially what they're saying here. Were the court to conclude otherwise, however, the proper remedy would be the dismissal of the resultant tainted indictment. So what are you going to say? You're going to say, well, no. The judge, maybe you'll say, no, this is too bad. No, this is too prejudicial, and who knows what Kate Peter did, and therefore whatever videos were presented to the grand jury corrupted the grand jury proceedings, and we have to dismiss those indictments. Well, guess what? Those indictments were the wiretapping indictments, which are essentially dismissed, and nothing to do with the witness intimidation charges. Now, how do we know that? How do we know that? How do we know that? How do we know that those videos only have to do with the wiretapping? How do we know that? I mean, I think the only way you can understand that, the only way you can get to the bottom of that is if you have an evidentiary hearing. And that's just that's my thought. Otherwise, I don't see how they're able to prove that. Okay. As for the indictments actually before this court, to the extent she and Mr. Carney share a mutual loathing, and they clearly do, and to the extent to which they may desire to see, and to the extent to which she may desire to see him hurt, humiliated, and imprisoned, and apparently she does, the question for the court, and ultimately a jury, should a trial judge permit counsel to go down that particular road, is not the bias of any particular informant, but the reliability of the evidence. The Commonwealth's evidence before the grand jury consisted of videos indisputably made by Carney. Okay, now we're going to just talk about the other videos made by Carney, documenting his own actions and the testimony of his victims as to their knowledge of those actions and the impact they had on their lives. It matters not a whit who informed the Commonwealth of any particular video's existence. Meaning, yeah, if those videos existed and K. Peter just said, hey, take a look at Turtleboy's episode 580. Okay, you're right, 100%. Then you're not relying on K. Peter, right? Okay, everyone agrees with that. What about those videos that are no longer available, that were taken down? Were there any editing done to those videos? And were they only as related to the wiretapping? We need those answers. We need those questions answered. What matters is the authenticity of the evidence. So now they're saying, okay, well, if we eventually got those videos from Turtleboy's website, so then okay, we're all good anyway. All right, fine. I agree. If they got all the videos from Turtleboy's website, then you're right. But the other part is still a problem. He does not make those representations because he cannot. At the end of 30 pages of memorandum of law, 88 pages of meandering argument, mislabeled as an affidavit, meaning not calling it a motion, and a host of exhibits, the defendant's contentions amount to nothing more than sound and fury, signifying nothing. What do you want? I like it. I like it. I like it. I enjoy it. Okay. I mean, maybe you shouldn't do it this may be a little bit overkill. You know, some people may say that even for Snark Daddy, this may be a little overkill, but I like it. What do you want from me? Okay. I like it. All right, let's move on. I mean, it's entertaining. Is it not entertaining? I mean, it's more entertaining to read this than to read, just blah, 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 blah. Okay. Next. What about the discovery? We have some major discovery problems here, right? They didn't turn over certain discovery. So now this is going to be their excuse about the discovery. All right. So hold tight because we're going to be a little bit of rambling here. The Commonwealth promptly provided the defense with extensive discovery, as borne out by the items set forth in undersigned counsel's letter to Attorney Bradel of May 8th, 2024, also notable for its expression of undersigned's belief, naive in retrospect, that discovery was then almost complete. Yeah, they thought this discovery was almost complete in May 2024, and still they're getting documents in September of 2025. Okay, so yeah, we made a mistake. It was silly. It was naive for us to believe that the discovery is going to complete, but we thought at that point we were hopeful. We were optimistic that at that point discovery is going to be over almost. This court should take note of discovery itemized in that letter, the subsequent discovery letter of June 13, 2024, and indeed the Commonwealth filed and docketed responses to the defendant's previous discovery motion in measuring the veracity of the defense's claim that since Mr. Carney's 2023 indictment, the Commonwealth has exhibited breathtaking indifference to its constitutional and statutory obligations to disclose evidence to the defense. Discovery has continued since that time, with the Commonwealth responding to defense requests, and the defense in turn finding problems with the discovery provided, alleging missing discovery. Sometimes correctly so, right? Remember the 4,000? Remember the 4,000 blank pages? Alleging missing discovery. It's not an allegation. They said sometimes correctly so. It's not. If it's correct, then it's not an allegation. It's just what we call the truth. It's a fact. So yes, there was missing discovery. Continuously generating new discovery requests and demanding further explanation of discovery already provided. Well, when you provide inaccurate or not complete, incomplete discovery, then that's going to prompt more action, of course. So, yeah, it has continued, and you've provided missing discovery, 4,000 blank pages. All right, some of the Commonwealth's problems have been logistical, and these are logistical problems. Okay, these are logistical problems, which are not the defendant's fault, not your fault, but inform the realities of production. I mean, this is just logistical issues, okay? It's just hard. It's hard. We can't just always do this. We can't always provide for you all the discovery when you want it, okay? It's just there's too many logistics going on here. I got to go into my email. I got to press forward to the defense. These are logistics that are very difficult to wrap our heads around, and it takes a team. It takes a lot of team. It takes a lot of time. We got to get together. We have to have some meetings about this, about how to forward discovery. So I mean, it just takes time, okay? It's not your fault. It's not your fault. You're doing everything fine. It's our logistical issue, and you're right. It is your issue. I mean, the fact that this isn't like a civil litigation here when you're quibbling about discovery and not turning over discovery and playing discovery games. This is a prosecution. There's a prosecutor. There's different obligations, but this is what we're hearing from them. Okay. By way of background, the investigation into Carney began about May or June of 2023. Attorney Mello, a resident of Bristol County, was engaged as special prosecutor on or about September of 2023. 6 months later, in March of 2024, the Norfolk District Attorneys recruited the undersigned to assist Mr. Mello with some legal research, writing, and similar tasks. Mello, however, proved to be gravely ill and has been physically unable to appear in court, requiring the undersigned effectively to assume full responsibility for the case. In point of fact, the undersigned has never been able to meet with Mr. Mello in person. That's how gravely ill he is. That Cosgrove was never able to meet him at all in person since March of 2024. That's how gravely ill he is. In point of fact, we said this. Okay. Has not been met in person since undersigned counsel's entry of an appearance in any case against Mr. Carney. While counsel has largely been able to obtain discovery materials directly from the Norfolk District Attorney's office, some of the necessary materials have been in Mr. Mello's possession, and his ongoing health problems and intermittent hospitalizations have retarded the process of acquiring them. Yeah, it's been very difficult. Say, I can't get everything from Mello. What do you want from me? He's gravely ill. He's running back and forth to hospitals. I know if that's true, okay, fine. So if he's got some sort of document that you can't get access to, good excuse, right? Good excuse. If the guy is deathly ill, gravely ill, and he's running back and forth to hospitals, how are you supposed to actually get documents that he has in his back pocket if that's where he keeps the documents? But this is also why you need what? An evidentiary hearing. Because what efforts were made? What did you do? How did you go about trying to get the discoverable information? Those are questions that need to be answered. That's what evidentiary hearing is for. So, to return to the previously mentioned May 8th, 2024 discovery letter, the court will note that in addition to the discovery produced by undersigned counsel, references discovery previously provided by Lieutenant Tully, given Mello's illness then hoped to be transitory, Tully was employed in the prosecutor's normal role of providing discovery. Another difficulty, so we're just laying out the difficulties. Okay, so Mello, Cosgrove got brought on the case already March 2024. Initially, he was just supposed to assist Mello. Then Mello got too ill, and now Cosgrove got to take over the whole file. So I'm gonna got chased down all this discovery in March of 2024, and it just takes about a year and a half. That's reasonable. It takes about a year and a half to get up to speed and to get all the discovery, right? I mean, there's no more questions that need to be asked about that. Well, what possible questions would you have? And this is just the perfect excuse. I mean, this is it. It's just a perfect storm that just happened. And Cosgrove got thrown into this position. Mello's running back and forth to the hospital, and I'm in the office scratching my head for a year and a half, trying to figure out how to get the discovery to you. All right. So another difficulty with discovery in this case has been the ongoing nature of the defendant's conduct towards the alleged victims and witnesses. So yeah, he's out of his mind. Turtleboy's just out of his mind. To reiterate just a few previously brought to the attention of this court or others, there was his online hope that Lieutenant Tully would die horribly along with his wife and children, charmingly coupled with Carney's self-comparison with Jesus. His nose to the window antics and accusations in the form of questions at the Albert Pizza Shop, captured by the security camera. His recent drive-by outside the Cape Cod home of a witness in the Karen Reed case. His discourse as to whether or not an officer's wife was blue because Carney speculated that she gave... Okay, we're not going to read that. And his repeated libels of Jennifer McCabe as a murderer. These and a host of other antics, some relatively minor, some offensive, but clearly legally protected speech. Wow, I never thought that I would see that term used in the Commonwealth's papers, because they know that this is clearly legally protected speech, what he's doing now. This isn't witness intimidation. So again, these host of antics just prompt the victims to contact the district attorney's office, often by email, questioning whether action can be taken, whether the conduct is a bail violation, etc. So all these witnesses are now flooding the district attorney's office with emails and statements. And what are we supposed to do? Just forward them all to the defense? Yeah, sure. That's a great idea. Why not? Is there a problem with that? Is there a problem? Here, Jennifer McCabe has launched another complaint. Oh my gosh. Do I have to press forward on this email? Are you serious now? I have to press forward this to the defense counsel and say, here's another statement. I mean, seriously, do I really have to do that? I mean, what do you call me, a prosecutor? Yeah, that's what you should do. That's exactly what you should do. 2 words. Do it. Go ahead, just do it. All right. So these are just all the discovery problems because it's just constant. There's more actions that Turtleboy takes, and then there's more statements that these witnesses give. And now they're going to try to argue, well, some of them may not be discoverable. Some of these statements may not be discoverable because, bad acts and yada, yada, yada. Okay, whatever. All right. So, getting more into that. So that's the reason why they had such a trouble with discovery. Okay, then we get into Gittany. The defense focused much of its criticism on the Commonwealth's provision of discovery concerning Catherine Peter, which it claims supports its preposterous theory that she, Lindsay Gittany, Mr. Mello, and Detective Tully, and possibly others diabolically plotted to have Mr. Carney's bail revoked by luring him into intimidating Ms. Gittany after they made her what Mr. Beddoe describes as a witness, taking care to put the term in scare quotes. Witness. Are you scared yet? Discovery provided by the Commonwealth shows that Gittany was indeed a witness. What? Wait, did you just say that Gittany is a witness? If Gittany is a witness, what does that make you, Mr. Cosgrove? Conflicted? Certainly sounds like it. If you're acknowledging that she's a witness in this case, that should definitely make the conflict right in the face. All right, anyway. Discovery provided by the Commonwealth shows that Gittany was indeed a witness interviewed by the police with specific attention to what she knew about Carney's ongoing communication with Karen Reed, right? That's what she was brought in. What do you know about this intermediary, yada, 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 etc. So that would be included in the witness intimidation charges. Okay, so going through all of the ideas about what Gittany would do and what their claim is. The defendant has complained repeatedly that the phone text of that evening between Gittany and Tully. Now, remember, it goes through the entire story of Gittany and Turtleboy and that whole story that we all know about. Okay, so now Gittany was texting with Tully that night. That night, when Turtleboy said, okay, let me go over there, and he's writing things down in his notebook and all that stuff. Well, Gittany was texting with Tully. Where are those text messages? The defendant has complained repeatedly that the phone texts of that evening between Gittany and Tully were not included in the subsequent copy of the download of her phone provided them by the Commonwealth. So somehow they escaped the download. And they're not there in the download. Undersigned counsel explained why that was the case in his letter to Attorney Bradel, telling him in pertinent part, if there is data missing, that is because it was missing when the phone came into the Commonwealth's possession, custody, and control, and thus we do not have it. So I guess their downloading software is not able to retrieve deleted messages. That's what you're going to have to assume there. The Commonwealth later secured the missing texts with Tully by means of copying them from his cell phone and handed them to counsel in open court during a hearing. So in sum, the defendant wishes to tell a jury that the Commonwealth engaged in a plot with Kate Peter and Gittany to make her a witness, then lure him to her apartment, provoke him to criminal conduct, then arrest him so his bail could be revoked. So cunning were the alleged plotters that Ms. Gittany studiously avoided any mention of their plot in its apparent progress when texting Tully. Nothing like, it worked, or he's here now, arrest him. So this is their gotcha moment. Their gotcha moment is, well, if this was all a plan, then Gittany would have texted Tully, ha, we did it. Smack 5. It worked. He's here. Arrest him. And there's no text messages like that. See that? There was no plan. Because if there would be a plan, you would have found that text message. Oddly, neither Tully nor any other officer was outside Gittany's apartment waiting to burst in. Also this part. There's no officers stationed outside of Gittany's apartment waiting to burst in the door and arrest Carney at the appropriate moment and not incidentally protect Gittany from any harm. All right? Who knows if Gittany's going to be in any harm? I mean, she's being used. She's a pawn. And who knows how Turtleboy is going to react with her. This is all one big plan. Maybe she needs protection. So that's, according to the Commonwealth, very odd that if this was all one big plan, then there would be police officers stationed right outside her home. Equally oddly, Gittany never reported the incident to the local police the following day, a lapse that prompted her alleged co-conspirator, Tully, to make the call. Oh, so Tully made the call and not Gittany. I mean, that wasn't part of the plan. That was not part of the plan. Okay, but Tully was the one who had to make the call. I mean, this is really a plan. Then Gittany would have called Tully. Truly, this defense theory is Lincoln-esque, at least in the sense that Lincoln has been quoted likely falsely, as saying, you can fool all the people some of the time and some of the people all the time. So yes, obviously, the defendant is correct that the Commonwealth thinks little of his theory. It doesn't matter what the Commonwealth thinks about it, by the way. But indulging the defense's contention that the Peter discovery was required, irrespective of the Commonwealth's subjective belief in the reliability of the evidence, and further assuming arguendo that its conspiracy theory would be admissible defense against the now dismissed Gattani indictments, which is exactly the point, how probative is it of the indictments before this court where Gattani is not a victim? There's not a victim? And if she's not a victim, is she a witness? The video evidence against the defendant was the product of his own hand. Yes. So wait, you're going back to the video evidence now? They keep liking going back. They go back to the video evidence. And it's all about his YouTube presentations. Let's ignore everything else. Ignore what Kate Peter sent him and maybe what she edited and just trust us that it's about the wiretapping and Gattani's not the victim in this case. So don't worry about anything that happened with Gattani and her this conspiracy theory that Turtleboy drummed up. Let's just ignore all that fact and let's concentrate on the videos. The video evidence against the defendant was a product of his own hand. Kate Peter did not organize, participate in, or induce the defendant to organize or participate in, film, and broadcast the rolling rallies in which the defendant led a caravan of cars to the doorsteps of witnesses, harangued them, and intimidated them using a bullhorn. Neither did Kate Peter compel the defendant to dox and defame witnesses or their family members. The defendant did that all on his own. And to what extent has the defendant been prejudiced by any delay in disclosure of the Peter discovery, as he repeatedly asserts? If prejudice at all, he has not shown it. Well, if they don't exist, the links don't exist, then that's prejudice, right? The defendant also has a related complaint concerning discovery concerning Ms. Peter, the counsel alleged failure to preserve exculpatory evidence. This is exactly where they're going with it, my thought. What about the things that are deleted that they have no access to? The counsel provided in the discovery various emails sent by Ms. Peter, some to Mr. Mello, some to Lieutenant Tully. Certain of those emails contained links, usually judging by label or context, to various online broadcasts by the defendant. Tully's general practice, by no means exclusive to him, was not to access links in unsolicited emails sent from parties outside the NDA's Office Criminal Justice Network. Mello, on the evidence of one response to a Peter email suggesting he was unable to access the content, apparently did so, at least on some occasions. So this is them again admitting to what Betterow pointed out in the motion to dismiss that, hey, you're going to try to argue that nobody accessed it? Mello did access it. He did access this link that Peter sent him. And this is them saying, yes, yeah, you're right. You got us. He did. But don't worry about it. Just ignore the guy behind the curtain. That has nothing to do with anything. Why? Well, because it's probably not exculpatory. Well, how do you know if it's not exculpatory? Mello's gravely ill. Is he going to tell you it's not exculpatory? The email remains, but not all of them have links to that are active. They have not been successfully accessed by undersigned counsel, and Tully and defense counsel also report that those links are dead. Why they are dead is wholly speculative. You're right, they're speculative, but guess where that goes in favor of? If it's speculative, you don't get to say, well, then it's probably not exculpatory. That's not how this works. You had access to that link. That link could have been exculpatory. And now the link is not active anymore because you didn't save it or the way that you're supposed to save it if you're conducting an investigation. And now it's destroyed. And it's Kate Peter. And maybe there was some video and understanding how much Kate Peter despises and is the arch enemy of Turtleboy. There could have been some very helpful, if they'd be able to access that video and see exactly what she provided. Maybe there's something edited there. It's not unreasonable to believe that there may be something exculpatory. Now, whether the actual video itself, the content of which is exculpatory, is not really the point. Yes, of course, Kate Peter is probably going to send something that looks very bad to Turtleboy. You're right. The actual substance of whatever she's sending is probably not exculpatory. But what she did to it, possibly, potentially, reasonably, could be, if she altered that video or whatever was in the link, then it's extremely exculpatory because this is one of the lead witnesses, the star witnesses, one of the people that are helping Tully with this in prosecution. So this is basically what they're arguing. They're going to argue that this is all not it's not exculpatory, and then they talk about Casablanca. For example, if someone sends an unsolicited email saying that it just goes on. This is just like rambling. For example, if someone sends an unsolicited email saying that the defendant looks a lot like Humphrey Bogart and attach the link to Casablanca, is it sufficient to simply save the email, or must the Commonwealth download and preserve a copy of Casablanca? Yeah, I mean, So they're going to say, well, okay, so now is it our obligation to check out all links? Let's say the links have malware, and maybe they have something to do with it. Well, were the links accessed? Let's ask that question. Can somebody answer? Well, Mello apparently did at some point access some of them. So we got to have an evidentiary hearing. You got to bring Mello on this end. If he can't answer it, well, then we do know that somebody accessed it. If you access it, then yes, it is in your possession, custody, and control. But they're going to try to make this whole argument that, well, it's not. Well, if somebody just attaches a link, somebody sends a link to the police office and they never open it. Does that mean that the link is now? This is what this is the type of mental exercise that they're trying to do here. And yeah, so this is their next argument. Okay, so and then this is the next part. Given as the defense says, Peter's cooperation with the Commonwealth and her dislike of Carney, it hardly seems probable that she sent links to evidence she thought exculpatory. It really says exculpatory, but it really means exculpatory. So, yeah, like we spoke about, it doesn't matter what the substance of the video is. It matters about what they could have learned, what type of information they could have learned from the video, if it was edited or not, if it was changed or not, what else was there. There's a reason that it was taken down. There's probably a reason that it was taken down and you can't access the link anymore. There's a reason for that, right? Maybe let's have an evidentiary hearing about that. Okay. Anyway, so and then they're saying, okay, well then even if there is some links that they can't open, you shouldn't dismiss the case, yada, yada, yada. Okay, and then the motion to disqualify Attorney Mello need not be addressed because the issue is moot. Shouldn't say moot. Okay, so that is essentially the motion. So now let's go back. I mean, there's a lot of rambling here. We didn't even get through all of it because I just can't anymore. It's like an hour and 11 minutes already. So I just can't. But we touched on all the arguments. This is really all the arguments. And let's remember for a moment what the arguments were by Mark Betterow. Was there anything in there that addressed the opinions that Mello and Tully gave? Those were allegations that were made in Mark Betterow's motion. Was there anything in that response that addressed the problem with Tully giving opinions about what the intent of Turtleboy was when he made those videos, when he made those comments? Was there any of that? No, there was no response to that at all. No response. So it's important as lawyers, or if you're just filing this case, after you get a long response like that, 26 pages, your head might be spinning around you, but let's just go back to the basics. What were the arguments for the motion to dismiss, and did they address the arguments? There's a lot of rambling. So yes, they did address certain parts, but did they address the opinion part? No. Nothing in there I saw addressed the opinion part. Nothing in there addressed the punishment or the sentencing part. The fact that was mentioned. The fact that Tully mentioned the punishment for wiretapping in the grand jury proceedings. I believe it was Tully. Was there any argument about why that wasn't improper, why that didn't taint the grand jury proceedings? The only argument that they made was, well, it's a waiver. And again, the waiver issue only comes back to, perhaps, you can argue, the specific just basis for the motion to dismiss based on the corrupting the grand jury. But in totality, showing all of this misconduct together, then that is considered. It could be reconsidered now. So was there any answer to that? No. Was there any answer to why there was no limiting instruction that was given about the entire day that was wasted on Scanlon? Was there anything of that in the motion? Now, there may have been something in the affidavit, but you have to put it in the body of the response. I didn't see anything in the response about why there's no limiting instruction that was given by Scanlon, relevant to Scanlon, why they wasted an entire day on Scanlon. And also, by the way, if you do have a good excuse, so you have some excuse, well, you got to figure this stuff out before you go to the grand jury. Are you going to present it, or are you not going to present it? Do you have enough evidence? Do you not have enough evidence? Are you in the right jurisdiction? Are you not in the right jurisdiction? You figure that stuff out before you go to the grand jury. And if you don't figure it out and you decide not to charge, then you've got to give a limiting instruction, a curative instruction. Was that given? No. And was there any explanation to why no limiting instruction was given? No. Okay, let's go to the next part. What about Cosgrove having emails from Mello on December 16, 2024? And he did not forward till July 7th, 2025. What about that? So this isn't, well, I was trying to chase Mello in the hospitals and he's too ill, and therefore I don't know what's going on with Mello. No, these are emails that you had in your inbox from Mello. He already sent it. You had them by December 16th, 2024. and you chose not to forward it till July 7th, 2025 to the defense. What's the explanation for that? Because it's a logistical issue? What's the logistical issue? You've got it in your inbox. You don't have to go chase Mello down. You took over in March of 2024, right? Isn't that when you took over around that time? So then what happened? So there's none of that. So there's some areas of the motion to dismiss that was not responded to at all. And that's why you have to highlight those issues when you're replying to this or when you go to the oral argument. And then, by the way, if you love the word waiver, then you're going to have to make the argument, well, Your Honor, they waived these issues. You know, if you want to die in that hill, Cosgrove, you want to die in the waiver hill, well, you waived any argument as to these issues. Then what's good for the goose is good for the gander, right? So let's do it. All right. So that is it. Normally I don't go this long, but very entertaining motion, a very entertaining response. I enjoyed reading it. You know, I think some people would argue that it's just way over the top, way too much snark. And I understand that argument. You know, a well-placed piece of snark can do better than the entire thing being a comedy skit. But you know, they wanted to write this way, and I enjoyed it, quite frankly, because it was very entertaining and it's great for YouTube. I'm not sure if the judge appreciates it as much. All right, so that is going to be it for today. If you haven't yet, please subscribe, like. We'll see you tomorrow at the special Thanksgiving stream with the family. Talk about some family politics. We'll talk about some other stuff. Bring your questions. We can maybe address some of the questions that you have, and that is going to be it for today. We'll see you tomorrow.